What's an admission and what's an answer? Conditional acceptance and other bad ideas. Brought to you by YourLegalLegUp.com, your advantage if you're being sued by debt collectors. A viewer told me about some trouble she had gotten into with something she called a conditional acceptance. And apparently what that is that you start every sentence with, I conditionally accept your offer, conditioned on, etc., etc., etc. The idea sounded like something she'd gotten off the internet, of course, and it sounded far-fetched, but I thought that was all. I should have known it was another scam going around, right? People are making money off of tempting people into doing this thing and looking for magic words or, solutions to the problems that they're facing. Conditional acceptance will not do you any good. We'll talk about that in this video. First, though, what would you say are the main lessons that come from the weaknesses intrinsic to a debt collector's case? They have a hard time proving that you owe the money, that you owe them the money, and how much money you're supposed to owe. And they have that problem because of certain evidentiary problems. They have a hard time getting evidence that is admissible in court for these things. Now, they can sometimes prove them, but most of the time they really can't, if you put up an intelligent defense. So the main lesson from that is never admit you owe the money, never concede you owe it to them, and make them prove how much it is if they can. These are the ways that you can win, simply by making the debt collector prove its case and by not giving anything away. The rest of what we do and say is really just to protect or improve your ability to do these things, or to show that the debt collector can't do what it needs to do. And the opposite is also true. The worst thing you can do to your chances of winning is to admit stuff. Admitting you owe it to them, or any particular amount you might owe, reduces the burden on the debt collector. If that happens before litigation, it makes it more likely you will get sued. And if it happens during litigation, it makes it more likely you will lose the case. Now let's talk about conditional acceptance. The person who talked with me had apparently filed a letter in response to a petition, starting with a conditional acceptance to the petition, stating that the acceptance was an offer, was an acceptance of the lawsuit, which was, in its view, an offer, and it was conditioned on the debt collector coming forward with various sorts of proof that the person, we'll call her Ms. Smith, didn't think they could bring. Now, incidentally, I'm pretty sure Ms. Smith is right about that, and that carefully read, her conditional acceptance was no acceptance at all. So what was it legally? Legally, Ms. Smith's conditional acceptance of a petition was just noise. If you get served with a petition, you must either file an answer or some sort of appropriate motion. A lawsuit is not an offer that can be accepted. It's the invocation of legal process, a process that will end in judgment. And if you don't file an answer or appropriate motion, the judgment is likely to be a default judgment. For some reason, the plaintiff didn't ask for a default judgment in Ms. Smith's case. I'm pretty sure I would have if it had been me. What it did do, however, was treat Ms. Smith's conditional acceptance as a settlement agreement or as a settlement offer. That isn't quite clear. But what happened is the case got put on the settlement docket. The court thinks the case is settled and is gone. I expect that settlement's going to come undone. It could cause, or create lasting legal damage depending on what part of the acceptance, if any, the court considers to survive the conditions that don't get met. It would appear that Ms. Smith's acceptance left the debt collector's right to collect and the amount in dispute as unchallenged and accepted. But who knows? It's a gray area. Whatever it is, though, it will be relatively easy for the debt collector. The fight will be over things that don't need witnesses or hard to get evidence, and that's where the debt collectors make their money. The court might even decide to enforce the settlement while not requiring plaintiff to show admissible evidence of the things said in the petition. But beyond that, remember the most difficult challenge a pro se party has is to get the judge to take her seriously. Judges spend most of their time in a legal atmosphere. They know lawyers, judges, politicians, legal clerks, and the rest, and all of them know the law and speak the law when they're dealing with it. A pro se party comes into that atmosphere and tries to get heard without, knowing the legal speak. They're facing a headwind. The court doesn't really expect you to know the law, and if you want to get the judge to do what you need, you have to overcome that presumption. So a conditional acceptance, which sounds like an acceptance, but actually isn't, is really just confusing the matters, and it's going to hurt you with the judge. Now, judges generally like to do what's right in a real world sense, and they like to look at what's actually happened. So you have a chance if you can make some common sense for them. But they are busy, and if you come in with nonsense, they'll figure you don't know what you're talking about. Talk about the debt collector having the burden of proof, or it's failing to satisfy the business records exception. You're talking their language, the language of the law. Try to duck behind some magic phrase like conditional acceptance, and you'll lose the judge's attention for the rest of the case. You confuse the court, and you annoy them because they think you're, making believe about something. They figure you owe the money, and judges are busy. Most of them don't see much point in letting you continue to take up their time if you don't make sense, and if you seem to be trying to avoid paying something that you owe. They're not really that much into the process. Speed and efficiency are important to them. They handle a lot of these cases every year. If you'd like a much more detailed analysis of what Ms. Smith did to herself, what the effects of conditional acceptance can be, and why you should never do it, check out the link in the About This Video section. We look at the actual mechanics of contract law in the article. It gets a little too involved for a video. You have an excellent chance of winning your case using legitimate tools provided by the law and the rules, and given the economic realities underlying the debt collection business. You don't need magic. Don't throw your chances away on some will-o'-the-wisp internet scam. Forget about conditional acceptance. Helping people protect their rights is what we do. Protect what's yours and don't let the debt collectors rip you off. Take action to protect yourself from the debt collectors and help others do the same. Please like this video, share it with anybody you think could use it, subscribe and comment, as all these things help other people find our materials. YourLegalLegUp.com